Hey y'all, it's Kim again. So this would be video 4, and it's pretty much like an appeals court to allow certain disclosures of the Epstein documents, like certain court cases, like the defamation stuff between Virginia Giuffre and Ghislaine Maxwell, or anyway, they're just going through a bunch of stuff right now, but it's like 2,000 pages, so it may take a while to get through it all, but I'm not letting this one go because it's got some interesting stuff in here. It's mainly talking right now about Virginia Giuffre pretty much didn't accuse Ghislaine Maxwell initially, and I don't even think the initial detective did either. That Maxwell was kind of like not involved, so I'm not really sure about that part because I like whatever. But I know their main focus was on Epstein, sex trafficking these kids. But anyway, whatever. We're just gonna go through the documents, and whoever wants to go back and read it, watch it, whatever. I'll put it in the description. You can have at it. But anyway, let's go on. So here we've got number 51. This is page 47. So plaintiff, which will be Giuffre or Roberts, publicly peddled her story beginning in 2011. Plaintiff did journalist Sharon Churcher extensive interviews that resulted in 7 widely distributed articles from March 2011 through January of 2015. Churcher regularly communicated with plaintiff and her attorneys or other agents from early 2001 to the present day. Plaintiff received approximately $160,000 for her stories and pictures that were published by many news organizations. Plaintiff drafted a 144-page purportedly autobiographical book manuscript in 2011, which she actively sought to publish. In 2011, contemporaneous with her Churcher interviews, plaintiff drafted a book manuscript which purported to document plaintiff's experience as a teenager in Florida, including her interactions with Epstein and Maxwell. Plaintiff communicated with literary agents, ghostwriters, and potential independent publishers in an effort to get her book published. She generated marketing materials and circulated those along with book chapters to numerous individuals associated with publishing in the media. Plaintiffs publicly filed lurid CVRA pleadings, initiated a media frenzy, and generated highly publicized litigations between her lawyers and Alan Dershowitz. On December 30th, 2014, plaintiff, through counsel, publicly filed a joinder motion that contained her lurid allegations about Miss Maxwell and many others, including Alan Dershowitz, Prince Andrew, Jean-Luc Brunel. The joinder motion was followed by a corrected motion and 2 further declarations in January and February of 2015, which repeated many of plaintiffs' claims. These CVRA pleadings generated a media maelstrom and spawned highly publicized litigation between plaintiff's lawyers Edwards and Castle and Alan Dershowitz. After plaintiff publicly alleged Mr. Dershowitz of sexual misconduct, Mr. Dershowitz vigorously defended himself in the media. He called plaintiff a liar and accused her lawyers of unethical conduct. In response, attorneys Edwards and Castle sued Dershowitz, who counterclaims. This litigation in turn caused additional media attention by national and international media organizations. Plaintiff formed nonprofit Victims Refuse Silence to attract publicity and speak out on a public controversy. In 2014, plaintiff, with the assistance of the same counsel, formed a nonprofit organization, Victims Refuse Silence. According to plaintiff, the purpose of the organization is to promote plaintiff's professed cause against sex slavery. The stated goal of her organization is to promote plaintiff's professed cause against sex slavery. Sorry, I messed that up. The stated goal of her organization is to help survivors surmount the shame, silence, and intimidation typically experienced by victims of sexual abuse. Plaintiff attempts to promote victims. Victims refuse silence at every opportunity. For example, plaintiff participated in an interview in New York with ABC to promote the charity and to get her mission out to the public, dated January 6, 2017, and then respectfully submitted Laura A. Manager, and then Jeffrey S. Pagliuca. I don't know what that pro hack vice or beast say, whatever, attorneys for Ghislaine Maxwell. Certificate of service. I certify that on January 6, 2017, I electronically served this defendant's statement of material undisputed facts pursuant to local civil rule 56.1 via ECF on the following: Sigurd S. McCauley, Meredith Schultz, Boyce Schiller and Flexner, Paul G. Castle, Bradley J. Edwards, Farmer Jaffe Weissing, Edwards, Fistos, and Larman, and then J. Stanley Pottinger, 49 Twin Lakes Road, whatever, South Salem, and then Nicole Simmons. Let's see. United States District Courts. I'm wondering if this is the same. Okay, memorandum of law in support of defendant's motion for summary judgment. Laura A. Manager, Jeffrey S. Pagliuca. And a table of contents. We're not going to worry about that because we'll just go through it. Let's see. Okay. Table of authorities. Okay. So former case logs, excuse me, if they're citing here. We're not going to worry about that. If you want to slow it down, stop it, or read it through the thing, you can. So defendant Ghislaine Maxwell moves under Federal Rule of Civil Procedure 56 for summary judgment. Preliminary statement facts. The following facts are undisputed. Additional undisputed facts are set forth in specific argument sections. All paragraphs containing undisputed facts will be sequentially numbered. Ms. Maxwell's response to publications of plaintiff's false allegations, the March 2011 statement. In early 2011, plaintiff in two British tabloid interviews made numerous false and defamatory allegations against Ms. Maxwell, Exhibits A and B. In the articles, plaintiff made no direct allegations that Ms. Maxwell was involved in any improper conduct with Jeffrey Epstein, who had pleaded guilty in 2007 to procuring a minor for prostitution. Nonetheless, plaintiffs suggested that Ms. Maxwell worked with Epstein and may have known about the crime which he was convicted. See generally Exhibits A and B. In the articles, plaintiff alleged she had sex with Prince Andrew. Sorry, I'm messing this up. A well-known businessman, a world-renowned scientist, a respected liberal politician, and a foreign head of state. In response to the allegations, Ms. Maxwell's British attorney, working with Mr. Gow, issued a statement on March 9, 2011, denying the various allegations about Ms. Maxwell that have appeared recently in the media. These allegations are also entirely false. Exhibit C. This statement read in full. A statement on behalf of Ghislaine Maxwell by Devonshire Solicitors, PRNE, Wednesday, March 9, 2011. London, March 10th, 2011. Ghislaine Maxwell denies the various allegations about her that have appeared recently in the media. These allegations are all entirely false. It is unacceptable that letters sent by Ms. Maxwell's legal representatives to certain newspapers pointing out the truth and asking for the allegations to be withdrawn have simply been ignored. In the circumstances, Ms. Maxwell is now proceeding to take legal action against those newspapers. I understand newspapers need stories to sell copies. It is well known that certain newspapers live by the adage, why let the truth get in the way of a good story? However, the allegations made against me are abhorrent and entirely untrue, and I asked that they stop, said Ghislaine Maxwell. A number of newspapers have shown a complete lack of accuracy in their reporting of this story and a failure to carry out the most elementary investigation or any real due diligence. I'm now taking action to clear my name, she said. Media contact, Roscoe, acuity, reputation. So Exhibit C, emphasis supplied, capitalization altered. We refer to this as the March 2011 statement. A plaintiff's gratuitous and lurid accusations in an unrelated action. In 2008, two alleged victims of Epstein brought an action under the Crime Victims' Rights Act against the United States government purporting to challenge Epstein's plea agreement. They allege the government violated their CVRA rights by entering into the agreement. See Exhibit D at 2. 7 years later, on December 30th, 2014, Ms. Giuffre moved to join the CVRA action, claiming she, too, had her CVRA rights violated by the government. On January 1st, 2015, Ms. Giuffre filed a corrected joinder motion, Exhibit D at 1 and 9. The issue presented in her joinder motion was narrow: whether she should be permitted to join the CVRA action as a party under Federal Rule of Civil Procedure 21, specifically whether she was a known victim of Mr. Epstein and the government owed them CVRA duties, Exhibit E at 5. Yet the court noted the bulk of the motion consists of copious factual details that plaintiff and her co-movant would prove if allowed to join, brackets admitted. Ms. Giuffre gratuitously included provocative and lurid details of her alleged sexual activities as an alleged victim of sexual trafficking. At the time they filed the motion, Ms. Giuffre and her lawyers knew that the media had been following the Epstein criminal case and the CVRA action. While they deliberately filed a motion without disclosing Ms. Giuffre's name, claiming the need for privacy and secrecy, they made no attempt to file the motion under seal. Quite the contrary, they filed a motion publicly, Exhibit D at 1 and N1. As the district court noted in ruling on the joinder motion, Ms. Giuffre named several individuals and she offers details about the types of sex acts performed and where they took place, Exhibit E at 5. The court ruled that these lurid details are unnecessary. The factual details regarding whom and where the Jane Does engaged in sexual activities are immaterial and impertinent, especially considering that these details involve non-parties who are not related to the respondent government. Accordingly, these unnecessary details shall be stricken. The court then struck all Ms. Giuffre's factual allegations related to her alleged sexual activities and her allegations of misconduct by non-parties at 5 and 6. The court said the striking of the lurid details was a sanction for Ms. Giuffre's improper inclusion of them in the motion. See at 6 and 7. I don't know what this is, ID, whatever. The district court found not only that the lurid details were unnecessary, but also that the entire joinder motion was entirely unnecessary at 7. And then Ms. Giuffre and her lawyers knew the motion with all its lurid details was unnecessary because, as the court pointed out, the motion itself recognized that she would be able to participate as a fact witness to achieve the same result she sought as a party. See at 7 and 8. See also at 8. Noting that in the motion, Ms. Giuffre's lawyers said that regardless of whether this court grants the motion, they will call her as a witness at any trial. The court denied plaintiff's joinder motion at 10. And then one of the non-parties Ms. Giuffre named repeatedly in the joinder motion was Ms. Maxwell, Exhibit D at 3 through 6. According to the lurid details of Ms. Giuffre included in the motion, Ms. Maxwell personally was involved in a sexual abuse and sex trafficking scheme created by Epstein. Ms. Maxwell approached plaintiff in 1999 when plaintiff was 15 years old to recruit her into the scheme. Ms. Maxwell was one of the main women Epstein used to procure underage girls for sexual activities. Ms. Maxwell was a primary co-conspirator with Epstein in the scheme. She persuaded plaintiff to go to Epstein's mansion in a fashion very similar to the manner in which Epstein and his other co-conspirators coerced dozens of other children. At the mansion, when plaintiff began giving Epstein a massage, he and Miss Maxwell turned it into a sexual encounter. Epstein, with the assistance of Miss Maxwell, converted plaintiff into a sex slave. Plaintiff was a sex slave from about 1999 to 2002, and Miss Maxwell also was a co-conspirator in Epstein's sexual abuse. Miss Maxwell appreciated the immunity she acquired under Epstein's plea agreement because the immunity protected her from prosecution for the crimes she committed in Florida. Miss Maxwell participated in the sexual abuse of plaintiff and others. Miss Maxwell took numerous sexually explicit pictures of underage girls involved in sexual activities, including plaintiff. She shared the photos with Epstein. As part of her role in Epstein's sexual abuse ring, Miss Maxwell connected Epstein with powerful individuals so that Epstein could traffic plaintiff to these persons. Plaintiff was forced to have sexual relations with Prince Andrew at Miss Maxwell's apartment in London. Miss Maxwell facilitated plaintiff's sex with Prince Andrew by acting as a madam for Epstein. And Miss Maxwell assisted internationally trafficking plaintiff and numerous other young girls for sexual purposes. And plaintiff was forced to watch Epstein, Miss Maxwell, and others engage in illegal sexual acts with dozens of underage girls. In the joinder motion, plaintiff also alleged she was forced to have sex with Harvard Law professor Alan Dershowitz, model scout John-Luc Brunel, and many other powerful men, including numerous prominent American politicians, powerful business executives, foreign presidents, as well known well-known prime minister, and other world leaders. Plaintiff said after serving for 4 years as a sex slave, she managed to escape to a foreign country and hide out from Epstein and his co-conspirators for years. Plaintiff suggested the government was part of Epstein's conspiracy when it secretly negotiated a non-prosecution agreement with Epstein, precluding federal prosecution of Epstein and his co-conspirators at 6. And then the government secrecy, plaintiff alleged was motivated by its fear that plaintiff would raise powerful objections to the agreement that would have shed tremendous public light on Epstein and other powerful individuals, and that's 6 and 7. Notably, the other Jane Doe who joined plaintiff's motion, who alleged she was sexually abused many occasions by Epstein, was unable to corroborate any of the plaintiff's allegations. See at 7 and 8. Also notably, in her multiple and lengthy consensual interviews with Mrs. Church or Miss Churcher 3 years earlier, plaintiff told Miss Churcher virtually none of the details she described in the joinder motion, see Exhibit A and B. Miss Maxwell's response to plaintiff's lurid accusations, the January 2015 statement, as plaintiff and her lawyers expected, before District Judge Mara and the CBRA action could strike the lurid details of plaintiff's allegations. In the joinder motion, members of the media obtained copies of the motion, see Exhibit G. And then at Mr. Barden's direction on January 2nd, 2015, Mr. Gao sent numerous representatives of British media organizations an email containing a quotable statement on behalf of Miss Maxwell, Exhibit F, Exhibit G, and 33, 8 through 23. The email was sent to more than 6 and probably less than 30 media representatives. See Exhibit G. It was not sent to non-media representatives. Among the media representatives were Martin Robinson of the Daily Mail, P. Peachy of the Independent, Nick Summerland of the Mirror, David Brown of the Times, and Nick Always and Joanne Pugh of the BBC, and David Mercer of the Press Association. See Exhibit F. These representatives were selected based on their request from the joiner motion or after the joiner motion was filed for a response from Ms. Maxwell to plaintiff's allegations in the motion. See Exhibit G at 30:23 through 35, and then or 30:23 through 35:21, and I guess deposition Exhibit 3. An email to the media members read, to whom it may concern, please find attached a quotable statement on behalf of Ms. Maxwell. No further communication will be provided by her on this matter. Thanks for your understanding. Best, Ross, Gal, Acuity, Reputation. Jane Doe 3 is Virginia Roberts, so not a new individual. The allegations made by Victoria Roberts, they messed that up, against Ghislaine Maxwell are untrue. The original allegations are not new and have been fully responded to and shown to be untrue. Each time the story is retold, it's changes with new salacious details about public figures and world leaders, and now it is alleged by Ms. Roberts that Alan Dershowitz is involved in having sexual relations with her, which he denies. Ms. Roberts' claims are obviously lies and should be treated as such and not publicized as news, as they are defamatory. Ghislaine Maxwell's original response to the lies and defamatory claims remains the same. Maxwell strongly denies allegations of an unsavory nature, which have appeared in the British press and elsewhere, and reserves her right to seek redress at the repetition of such old defamatory claims. Exhibit F, emphasized flag. We refer to this email as the January 2015 statement. Mr. Barton, who prepared the January 2015 statement, did not intend it as a traditional press release solely to disseminate information to the media, so he intentionally did engage a public relations firm, such as Mr. Gow's firm. Mr. Gow's firm, Acuity Reputation, to prepare the statement. See Exhibit K, 10 and 15. The January 2015 statement served two purposes. First, Mr. Barton intended that it mitigate the harm to Ms. Maxwell's reputation from the press's republication of plaintiff's false allegations. He believed this could be accomplished by suggesting to the media that, among other things, they should subject plaintiff's allegations to inquiry and scrutiny. For example, he noted in the statement the plaintiff's allegations changed dramatically over time, suggesting that they are obvious lies and therefore should not be publicized as news. Second, Mr. Barton intended the January 2015 statement to be a shot across the bow of the media, which he believed had been unduly eager to publish plaintiff's allegations without conducting any inquiry of their own. Accordingly, in the statement, he repeatedly noted that plaintiff's allegations are defamatory. In this sense, the statement was intended as a cease and desist letter to the media recipients, letting the media recipients understand the seriousness with which Ms. Maxwell considered the publication of plaintiffs' obviously false allegations and the legal indefensibility of their own conduct. Consistent with those two purposes, Mr. Gow's emails prefaced this statement with the following language: please find attached a quotable statement on behalf of Ms. Maxwell. The statement was intended to be a single, one-time only, comprehensive response, quoted in full, to plaintiffs' December 30th, 2014 allegations that will give the media Ms. Maxwell's response. The purpose of the prefatory statement was to inform the media recipients of this intent. Plaintiff's activities to bring light to the rights of victims of sexual abuse. Plaintiff has engaged in numerous activities to bring attention to herself, to the prosecution, and punishment of wealthy individuals such as Epstein, and to her her claimed interest of bringing light to the rights of victims of sexual abuse. Plaintiff created an organization, Victims Refuse Silence, Inc., a Florida corporation directly related to her alleged experience as a victim of sexual abuse. The goal of Victims Refuse Silence was and continues to be to help survivors surmount the shame, silence, and intimidation typically experienced by victims of sexual abuse. Towards this end, plaintiff has dedicated her professional life to helping victims of sex trafficking. Plaintiff repeatedly has sought out media organizations to discuss her alleged experience as a victim of sexual abuse. In this motion at 51 and 54, as discussed above, on December 30th, 2014, plaintiff publicly filed an entirely unnecessary joinder motion laden with what Judge Mara described as unnecessary lurid details about being sexually abused as a minor victim by wealthy and famous men and being trafficked all around the world as a sex slave. Exhibit D at 1N1 through 6. The plaintiff's alleged purpose in filing the joinder motion was to vindicate her rights under the CVRA, expose the government's secretly negotiated non-prosecution agreement with Epstein, and shed tremendous light on Epstein and other powerful individuals that would show how Epstein used his powerful political and social connections to secure a favorable plea deal, and the government's motion to aid Epstein and his co-conspirators. See Exhibit C at 1, 6 through 7, and then 10. Plaintiff has written the manuscript of a book she's been trying to publish detailing her alleged experience as a victim of sexual abuse and of sex trafficking in Epstein's alleged sex scheme. Republication alleged by plaintiff. Plaintiff was required by interrogatory number 6 to identify any false statements attributed to Miss Maxwell that were published globally, including within the Southern District of New York, as plaintiff alleged in paragraph 9 of the count 1 of her complaint. In response, plaintiff identified the January 2015 statement in 9 instances in which various news media published portions of the January 2015 statement in news articles or broadcast stories. Exhibit H at 7 through 8, Exhibit I at 4. I'm going to stop here. I mean, I know I think they've just lumped in 2,000 documents. It may not be all about like the appeals court thing that I originally put, but I'm just going to leave that for now. And then if it starts changing, I'll change it to something else. But anyway, we'll talk to y'all later. But we're going to get through this document. Anyway, talk to y'all later. Have a good one. Bye.